Colin O'Keefe here for LXBN TV. Internet giant Amazon got into the TV streaming hardware market recently when they released Amazon Fyre TV to much fanfare, but they did so with little regard for another similarly named product. Joining me now to explain this trademark dispute is attorney Mike Palmisciano. He is an attorney with Sullivan & Worcester and author on the firm's blog, Trending Trademarks. Mike, first, what exactly is going on here? What are the claims against Amazon, and are they valid?
Right. Well, I think Real has a very strong claim here. Real filed suit in the Florida District Court for trademark infringement and three related state law claims. But really, the crux of their argument is a trademark infringement claim for likelihood of reverse confusion based on Amazon's use of Fyre TV. Back in 2007, Real produced a product called Fyre TV, Fyre TV, and they have a related website that goes along with it. The product is a device that you put on your television set. It streams video directly to your TV, but all of the video is pornographic material. And they have registered trademark rights in both the name Fyre TV and in the domain name. Come April 2014, Amazon rolls out its version of Fyre TV. Again, it's a set-top streaming device, plugs right into the TV. They're competing against Apple TV and Google Chromecast, but it's essentially very similar to what Real claims they pioneered back in 2007. And the claim here that Real is infringing on Amazon's trademark is very strong because Real argues that, well, the two products are pronounced exactly the same. They're spelled nearly identically, replacing a Y with an I. And the function of the products is identical. They're both viewed from a big picture standpoint. They're both streaming devices, hardware devices that you plug into your TV. Obviously, Amazon's going to argue that they're very different product markets. Amazon is marketing to consumers at large, while Real is marketing to consumers of adult entertainment. But courts generally take a bigger picture view of the infringing product, and they say, look, like the underlying product performs the same function, and so regardless of the product market, the court is likely to find likelihood of confusion here and likely to rule in Real's favor if it does go to trial.
I see. And then second, you mentioned a trial there, but really, how do you expect this to be resolved? And also, Amazon had to know about this trademark when they released the product, correct?
Of course. So I expect that this will be settled out of court well before it reaches a courtroom. Amazon, like you said, had to have known about this potential infringement case before it was filed. In fact, a very simple search of the USPTO's website for the term Fyre TV, Fyre TV, brings up the two marks that Real had registered back in 2007. So they must have known that it existed and that it was a similar product, but likely they didn't care because Amazon is interested in extending their Fyre brand of consumer electronics, the Amazon Fyre Kindle, and now we have the Amazon Fyre TV. This extension of the Fyre brand of products, in Amazon's view, was more valuable than the settlement resulting from this lawsuit, whether that's tens of millions of dollars or less. Amazon is really intent on expanding its brand and its product name at all costs.
Absolutely, absolutely. We'll never know for sure about the terms of this settlement, but I would guess it's going to be pretty large based on the fact that Amazon basically almost wiped out a whole company here. Once again, that was attorney Mike Palmisciano. He is with Sullivan & Worcester in Boston, and you can read more of his insight on this dispute at trendingtrademarks.com. Thank you for joining me today, Mike.
Thanks, Colin.